Welcome back to Yee's Law Journal. I'm your host, Josh. First off, Alice, and I want to extend warm holiday greetings to all our listeners. Merry Christmas and a very happy New Year 2025. We hope this season brings joy and relaxation to you and your loved ones.
And I'm Alice. We're thrilled to have you with us during this festive season. Today, we're diving into a fascinating and rapidly evolving topic. Generative AI, or Gen AI. From automating text creation to drug discovery, Gen AI's applications are expanding at an incredible pace.
That's right. With tech giants like OpenAI rolling out GPT-4 APIs and China's domestic models like Kimi, the commercialization of Gen AI is accelerating globally. But as exciting as these developments are, they also bring significant legal, regulatory, and ethical challenges.
Absolutely, Josh. Countries are scrambling to adapt their laws to keep up with this technology. For example, the EU's AI Act took effect on August 1st, 2024, establishing strict regulations to address ethical concerns and prevent misuse. Meanwhile, China has adopted a more agile governance approach.
Yes, China's path is especially interesting. In August 2023, China implemented the world's first dedicated generative AI regulation, the Interim Measures for the Management of Generative AI Services. Together with other regulations like the Trial Measures for Ethical Reviews in Science and Technology, these rules form the backbone of China's Gen AI governance framework.
Let's break down China's approach for our listeners. First, there's the concept of model filing. Josh, can you explain what this entails?
Sure, Alice. Under the interim measures, Gen AI services with public influence or social mobilization capabilities must undergo security assessments and file their models with regulators. This applies to AI systems generating text, images, sound, and even videos provided they target a domestic audience. Interestingly, this doesn't cover models solely accessed via APIs or those not directly facing domestic users.
And that's different from deep synthesis algorithm filing, which focuses on algorithmic processes, right?
Exactly. While both involve regulatory oversight, model filing prioritizes public-facing systems with broad societal impacts. This layered regulatory strategy reflects China's cautious yet supportive stance toward innovation.
Moving on to algorithm regulation. Since 2021, China has introduced annual laws targeting algorithm use. For instance, the Internet Information Service Algorithm Recommendation Management Provisions and the Deep Synthesis Management Provisions are key milestones.
And those culminated in the 2023 interim measures, which mandate compliance with algorithmic transparency, intellectual property rights, and data processing standards for Gen AI developers. This creates a robust legal framework for algorithms in China.
Let's not forget the broader context of Internet Information Services regulation. Gen AI often operates within the Internet ecosystem, which subjects it to regulations on content production and distribution. Providers must comply with laws like the Internet Information Service Management Measures.
That's correct, Alice. Gen AI providers face dual responsibilities: ensuring compliance with general Internet regulations and addressing specific obligations under the interim measures.
And what about Gen AI applications embedded in specific sectors? That brings us to telecom regulation, doesn't it?
Yes, Gen AI is often integrated into value-added telecom services like information or transaction processing. This requires providers to secure licenses under the telecommunications regulations and related rules. These include ICP licenses for Internet services or EDI licenses for electronic data exchange.
Another key pillar is ethical reviews. China's trial measures for ethical reviews in science and technology, effective since December 2023, emphasize the need for ethical oversight in AI activities. Developers must establish committees to assess risks and ensure compliance with ethical norms.
Beyond ethical compliance, there's the critical issue of data governance. Gen AI's lifecycle from model training to deployment and optimization raises complex data challenges. Developers must comply with foundational laws like the cybersecurity law, the data security law, and the personal information protection law.
Data sourcing is particularly tricky. For example, web scraping to collect training data involves legal risks, as does handling personal information or commercially sensitive data. Compliance demands strict adherence to transparency and consent requirements.
And once Gen AI models are operational, issues like privacy breaches or intellectual property disputes become prominent. Developers must navigate these risks carefully to avoid legal pitfalls.
Speaking of intellectual property, let's touch on some IP challenges. Josh, what's the debate around training data and copyright?
Great question, Alice. Using copyrighted works for training Gen AI models raises questions about fair use. Some industry experts point out that balancing innovation with intellectual property protections is crucial. They highlight the significant costs and time involved in obtaining proper licenses for large-scale training data.
Other commentators have also noted the challenge of defining fair use for AI training data. They emphasize that the legal landscape in China is evolving, with courts and regulators still interpreting how Gen AI aligns with existing copyright laws.
That's true. Analysts highlight that courts in China have started addressing these challenges, recognizing that Gen AI requires innovative regulatory approaches to ensure both technological progress and legal fairness.
And what about Gen AI-generated content? Can it be copyrighted?
That depends. Both Chinese and U.S. courts generally agree that content must demonstrate human intellectual input to qualify for copyright. But how much human involvement is enough remains contentious. Recent cases, like Beijing's ruling on AI-generated images, suggest growing recognition of users' intellectual contributions.
Before we wrap up, let's discuss accountability. Who's liable for infringement involving Gen AI content?
Liability often depends on whether service providers knew or should have known about potential infringements. Courts in China and elsewhere are still defining the boundaries of liability, especially when platforms lack direct control over generated outputs. Observers note that liability allocation in cases involving Gen AI-generated content remains a hot topic and will likely evolve with further court decisions.
This is clearly an evolving area, with much at stake for both regulators and innovators. Josh, any final thoughts?
Just that this is a space to watch closely. As governments and industries shape the future of Gen AI, legal frameworks must strike a balance between fostering innovation and safeguarding rights.
Well said. That's all for today's episode of Ye's Law Journal. Stay tuned for more insights into cutting-edge legal challenges.
Thanks for listening. And as we close, we'd like to wish all our listeners a joyful holiday season. May your Christmas and New Year be filled with peace, happiness, and success. Until next time,